Good morning. Okay, so I'm back, you guys. I don't know what happened to my live stream earlier. It just my screen blanked out and said that it was trying to load up something. I don't know. But anyway, I'm going to start over because I really want you guys to check this out so that you can see a little bit more about the details of when it comes to interpreting and actually researching on your federal codes. Okay, so we're going to start off with the code that I was looking at, which is here. This is 15 USC section 1635, the right of rescission as to certain transactions. So there's a term here that is not defined. Okay. And I want to go over just a simple process to make sure that I do understand what this undefined term is actually talking about because it requires performance. Okay. So I'm just going to read a little bit so that you understand why I was getting confused about why this term is not defined. So it says here, if the creditor has, and I'm kind of like, I'm right here. If the creditor has delivered any property to the obligor, oh, wait a minute. I'm losing my spot because I'm on two different screens. If the creditor has delivered any property to the obligor may retain possession of it. Upon the performance of the creditor's obligations under this section, the obligor shall tender the property to the creditor, except that if the return of the property in kind would be impracticable or inequitable, the obligor shall tender its reasonable value. Okay. Tender shall be made at the location of the property. So you can see that obviously a person is required to do something here and it has to involve tender. But we don't really know what tender is because, like these terms, we can't just click on it and it'll normally take you to another screen when you're looking for a definition on a hyperlink. But here we have an operative word, but it doesn't give us the definition of the operation. So we have to go digging. So, what I like to do in any case, when I'm looking for information to verify what the CFR does, there's two things. We're not going to make any assumptions about the definition. We're going to go research it, but we are going to make an assumption that because the CFR is written by the same organization, all of these codes are written by the same organization and they have their authorization from the same organization, that we can depend on their own interpretation of this word to apply to the rest of their codes, even if this code doesn't specifically outline the definition itself. Okay. So, how we're going to do that is we're just going to simply use the CFR, okay, as the search engine that it is, and we're going to research the word tender so we can figure out what it's talking about. Okay, and that's just the first thing we're going to do. So it says prohibited transactions in connection with partial tender offers. We don't necessarily have a direct reference to a tender offer. We only have a reference to tender. Okay, so I'm going to skip this one, especially because it's in this Title 17. It may not be the most applicable definition of tender that we can find. So I'm going to move down to definitions. Now, when you see this WEX, what you're looking at is a dictionary that the CFR uses to define terms. Most researchers like to use Black's Law Dictionary to do their legal terms. But of course, me being the person I am, I want to know what everybody thinks legal tender is. I don't care if it's just Black's Law Dictionary. I don't care if it's just a CFR. I don't care if it's WEX. I don't care if it's Webster. I don't care if it's Wikipedia. I want to know what everybody thinks tender is. Okay. So let's just go into this definition because it's to me the most relevant one. Legal tender refers to all U.S. coins and currency that's issued by the government. And of course, the government is a corporation. We're talking about anything that is owned or controlled by the federal government corporation. This means if it's an asset of the corporation, it's a part of the government. Okay. So U.S. cash dollars are also a form of legal tender. Nonetheless, federal statutes do not require a seller to accept cash as a form of legal tender for payment of goods or services that were rendered. Okay. Thus, businesses may establish their own policies regarding whether they will accept cash as a legal tender. Legal tender also includes Federal Reserve notes, as well as notes from Federal Reserve banks and national banking associations, like the American Banking Association. I think that's what it's called, for purposes of setting public and private debts, duties, dues, and taxes. Okay. And this is, excuse me, settling, not setting, settling public and private debts. And this is really important because this has to do with HJR 192 of 1933. Okay. Public and private debts, it became a thing when, well, I should say it became an obligation of the United States when the gold standard was removed in 1933 as a result of bankruptcy. Okay, so the duties, the dues, and taxes are all going to be um, settled using these legal tenders. Okay, so legal tender generally does not include personal checks, credit cards, hmm, or other general forms of non cash payment. Did you know that? What? That is crazy. What? Legal tender generally does not include personal checks, credit cards, or other general forms of non cash payments. In some instances, foreign currency may be accepted as legal tender. Additionally, legal tender can only be used in regard to paying off debts. You guys, I'm pretty sure you veterans of this research lifestyle already knew that, but I did not. I don't think I knew that. The purpose of the function, or excuse me, the purpose and function of legal tender is for courts to determine whether it is a satisfactory payment for monetary debt. Ooh, all these juicy words that they're using. Let's just click it. I can't help myself, y'all. I gotta click it. A court is any official tribunal presided over by one or several judges in which legal issues and claims are heard and determined. The U.S. system is composed of federal courts and state courts. Article 3, Section 1 of the U.S. Constitution establishes the U.S. Supreme Court as the highest court of the land. The Supreme Court has appellate jurisdiction over almost any case involving a constitutional or federal issue. The Supreme Court has also original jurisdiction over cases between two or more states and involving ambassadors and other public ministers. Okay. So I'm sorry, I just had to do it. What's monetary debt? This is interesting. Okay. See what Nolo's plain English dictionary law. Plain English law dictionary. Okay. And we're gonna get to some more uh definitions that are not in plain English, but this to me I think is a benefit. Number one, okay, we're calling debt. And it said monetary debt when we clicked on it, didn't it? How do we get from monetary debt to just now debt? Somebody got some explaining to do. That's inconsistent. An amount owed by one person or entity to another. So it involves a person or an entity. This is commerce. Every time we do business between each other or with the organizations, artificial structures that we do business with, okay, we owe them. We create transactions. We create debt because we owe them for whatever performance they have given us or whatever security interest we have exchanged. Okay, and that's what a securities exchange is: a cause of action in a lawsuit to recover a set amount owed by another, okay, another person or entity. A cause of action in a lawsuit to recover a set amount owed by another. And I think the amount set is the amount tendered or the amount paid. I don't think you can really pay a debt using any of the tenders that we typically use. The total of everything a person or entity owes to all creditors. I think it's really stupid that they use this as an example, but this is the example they use. Everything the United States government owes is collectively called the national debt, and that amount is made up of a number of debts. I mean, come on, Captain Obvious. Can you give us any less practical definition of what a debt is? That's just like a slap in the face for them to be telling us all this stuff. Let's look at what commercial activities is, you guys. This is really good. Abandoned application, abandonment of a patent or trademark application. Let's see. Abuse, generally, physically, sexually, or mentally injuring a person. Oh, look at that. Why would all this stuff be in here? What's all this? Oh, yeah, we looked at this. You guys, this is so good. Look at all these definitions. Definitions are really the best because I'm not going to get too far off, but the definitions really do give you understanding. Okay. So we're going to go read this last little piece and then we're going to go back and take a look at the code again, the original code we were looking at. The purpose and function of legal tender is for courts to determine whether it is a satisfactory payment for monetary debt. Each jurisdiction can define its specific limits of what is legal tender, but generally it is anything when offered or tendered. Oh, okay. Okay, so that's why they call it a tender offer. Oh, so we are going to go look at that. We are going to go look at that. Okay. It is anything when offered or tendered. Oh, and accept. It's funny how just things just click when you okay, when offered and accepted in order to pay off a debt. Although the original creditor who is owed money, okay, is not necessarily obligated to accept the tendered payment. The specific act of tendering the payment absolves the debt. What? So you say I could just act like I'm paying for something? I'm gonna just act like it and see. Okay. So many things happening in my mind right now. So many things happening in my mind right now because, first of all, I have to say, I don't like the fact that the law, the code does not differentiate between a creditor and an original creditor. Okay. Because a creditor, in general, is someone whom an obligation is owed. Okay. That can be us. Okay. Or it could be a business. And I don't like that the original creditor is not put into layman's terms or plain English as well, because there is a difference between a natural creditor or an artificial creditor, okay, or an original creditor and just simply a creditor. Those things are different. They're much different. I'm a living, breathing body. I am the source energy in which the credit is extending from. Okay. So if I, the natural generator, okay, I'm generating the energy, I'm generating the currency that is commodities or securities exchange. I am the currency. Me, my living breathing body is the currency. Okay, so if I am the original or natural creditor, then yeah, there's my definition. But don't just say there's a creditor who is in general somebody whom an obligation is owed. Yeah, you owe me quite a bit. Okay, this is something that I think, you can see where the deception is intended. You can see where deception is intended. Because if plain English in effect was to be the intention for understanding, then there would be a differentiation between those two definitions. Most commonly, the obligation owed is an obligation to pay money for some prior service or a loan. In bankruptcy law, someone who has a claim against a debtor that arose before declaration of a bankruptcy. Mm. So they have all these different relative terms. Oh God, I want to click on these things so badly, y'all. I just can't help myself. Look at that. Look at all these definitions. Oh, look at it. Ooh, look at all that. Okay. I'm not going to get off topic. I'm not going to get off topic. Go back. Please go back so I don't get distracted again. Okay. All right. So now that we've taken a look there, we're going back to look at tender offer. Well, let's just see what comes before this. Title of securities. And okay, I want you guys to understand that researching the CFR, it's not ever going to make sense. Okay. This is really just about your curiosity. As you can see, I want to know everything. So I'm clicking on stuff just so that I can gather the information. It doesn't necessarily have to be relevant, but chances are it is relevant because it's under the same tree. Okay. It's under the same tree of knowledge and information. So I like to click on it all because just to know what came before this. Like right now, we were getting ready to look at what was this definition, but I just had to see, what came before all of that. Where it's talking about the offer, the tender offer. What is all this? Okay. Sometimes when you just look around for context, you can find out a lot about what you're reading when you're looking around for context. Uh, I want to put it in context, so I need to see what's around it. What? Ooh. So let me get back here. I was in 17 CFR 240 14E. Okay, so if I'm in 240 okay, 240 14E right here. Unlawful tender offer practices. Position of subject company, okay, with respect to a tender offer. Transactions and securities on the basis of material, non-public information in the context of tender offers. Do I want to read that first? So material, non-public information in the context of tender offers. Ooh, that's okay. That's the one we were just looking at. Prohibiting purchases outside of a tender offer. Repurchase offers by certain unlawful tender offer practices in connection with roll-ups. I'm about to read all of this, but let me just go back to the one that I was. No, that wasn't the one I was on. Let me go back to the one I was on. Okay. The amount of a person's net long position. Is that the one I was? Oh, no, I want to see what the tender offer is about. I don't want to read all that. For the purposes of this rule, a person shall be deemed to tender a security. Okay, here we go. Okay, the term subject security means a security that is that is the subject of any tender offer or request or invitation for tenders. Oh, okay. Subject, the subject of any tender offer. For purposes of this rule, a person shall be deemed to tender a security if he delivers a subject security pursuant to an offer. Okay. So a security would be any kind of collateral agreement that you have that is perfected and attached. Okay. Something that you can actually pursue. Okay. Delivers a subject security pursuant to an offer that was made. Causes such delivery. Now, usually a security, like for example, when I went to buy my car, they tell me that I'm giving them a security interest in the car. If you go and look at the contract that you have on your vehicle purchase, you on the contract, you are giving the finance department or the company itself, you're giving them a security interest in your car because even though your social security account has paid for the transaction, they don't care about that. The credit has already been extended when you signed up for the application, when you did the application, when they, okay, run this number, see how much we can get back. That is the payment. Okay. That is when the transaction was finalized. You had to say, okay, even though the contract is now or the transaction is now finalized, okay, I have to still give you a security interest in my car because if I don't and I just take off now that the transaction is secured or that basically it's secured, um, you are not going to be able to get any payments from me because you won't have a security interest. So they have to get your signature that says you are giving the company a security interest, voluntarily giving it to them. Because if you were to cross that out and initial buy it, they probably wouldn't let you walk out with the car. They probably would not let you walk out with the car. But that is a problem because you have a every right not to give them voluntarily the security interest that they're looking to get from you. All right, so the term, oh, wait a minute, delivers a subject security, okay, pursuant to an offer, causes such delivery to be made, okay? Delivery of the car, delivery of the goods, okay? Deliver once the delivery is made, the security interest is established or final. I should say it's settled. Guarantees delivery of a subject security pursuant to a tender offer. Causes a guarantee of such delivery to be given by another person. Okay, causes a guarantee of such delivery to be given by another person. Okay, or okay, or uses any other method by which acceptance of a tender offer may be made. Partial tender offer. Mm-hmm. Okay, so I think I got enough about that from here. So let me show you another place where we're going to kind of poke around and see what we could find out about Tinder. Okay, so I'm gonna share something else with you if I can get it right. Um, I don't know. Uh-oh. That's not what I'm trying to do. Yeah, I don't know how to do this. Wait. Oh, there it is. Ha! All right, so we're gonna do some research over here in our database because I love it. We're gonna go to the training documents first, and then we're gonna go to our files, and then we're gonna search. Okay. We're going to look at Tinder. Now that we've seen what the CFR has to say about it in general, okay, we're going to look through here and we're going to look for Tinder. Hmm. Let's see. I wonder, do we have anything in Black's Law Dictionary? Uh, let's see. Okay. I wonder, can I search in this document for it? Okay, so we have a document that I just pulled up, which is a law book, a Harvard law book. So let's just see. Do we have anything in here about Tinder? Mm. Okay. Yep. We have negotiable instruments. Let's see if I can search inside this. Can I? What does it look like? I can't. Okay. So let me check. I'm about to go down to negotiable instruments 146 because that's what page it says. It's on. Page 146 is negotiable instruments, and usually that's when we start talking about tenders. Hello? Come on, boo, you gotta catch up. Where we at? I just did all that scrolling. I'm only on page number 25. Oh my God. Y'all bear with me, please. Bear with me because I gotta get there. I gotta get there. I gotta get there so I can see what it's talking about. For the life of me, I don't understand why that thing says that you might tender something and then they would come to collect the property. To me, that doesn't make sense. If I'm using the tender, how is it different than the property? Especially if my credit already tendered. Oh, but it says you can't use credit as tender. Is that not what it said? Ooh, is that not what it said? That you can't use credit as tender? Legal tender general does not include it. So this makes sense now. Okay. That makes sense. If you can't use credit, okay, tender shall be made at the location of the property if the creditor does not take possession of the property within 20 days after tender. by the obligor, ownership of the property vests in the obligor without obligation on his part to pay for it. So now you're using a term pay for it, but you're not saying tender, and the tender is not the property. You guys, yeah, somebody, we have to figure this out because that doesn't make sense to me. That just don't make sense. It doesn't make sense. Okay, let me get back to the screen that I'm looking at. It doesn't make sense. I need to come back and look at this. If the credit is not the tender, but the tender can be used. Let's go back. Wait, what did we say? Okay. This does not include personal checks. Da, 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 da. Legal tender includes Federal Reserve notes as well as notes from the Federal Reserve banks for purpose of settling public and private debts. But that doesn't. Duties, dues and taxes. Okay, so if it's just a legal tender and they want me to tender something, I mean, is this a not a legal tender? Because if I have to make tender at the location of the property of the residence at the option. Okay, but it says at the option of the obligor. So maybe I don't want to do that. If the creditor does not take possession of the property within 20 days after the tender, which I may or may not do, by the obligor, ownership of the property vests and without obligation on his part to pay for it. This gets on my nerves, you guys. I don't like it when these codes don't add up. Ugh, I hate that. I absolutely hate that. Because now you're saying pay for it. Pay for it how? The procedures prescribed by this subsection shall apply except when otherwise. Because I don't understand. If I rescinded my signature, uh, why would I pay for? Why would that have to be said? That I'm don't have an obligation to pay for it, but they're trying to figure out who is going to retain possession of the property, and that, oh God, I'm gonna have to invite some of you guys to come and look at this with me. Hold up. This is just too much. Mm. I'm like, please join this live so I can. Mm. Goodness gracious. Okay. Okay, so I am going to try a little bit longer to look for a definition. So I was in, okay, we're almost there. 146 is the goal. Let me get to 146. You guys, because I just have to figure out what they're talking about. I can't accept the fact that I don't know what they're talking about when they're talking about this legal tender. They're talking about this paying for stuff. They're talking about the possession of the property. It's too much for it not to be a definition. It's like, how can you say pay for it? But then you're giving me all these other definitions of what paying for stuff looks like. Pay for it how? If I can't use my credit card, my check, but I can use cash to I mean, oh, because maybe because a credit card or a check has to do with your actual securities, real securities. The money is not a real security, or the cash is not a real security. Ooh, maybe that's something that I need to figure out. Okay, so a negotiable instrument may be defined as a written instrument or evidence of a debt, which may be transferred from one person to another. Now again, I told you guys this is on my database. All right, we have a database here, um, and it is kind of lovely. All right, so it says a negotiable instrument may be defined as a written instrument or evidence of debt, which may be transferred from one person to another by endorsement and delivery. Endorsement meaning your signature on the instrument that has the instructions for which the transaction to occur, for the transaction to be executed. Okay, so you have the endorsement and delivery, or by delivery only, so that the legal title becomes vested in the transferee. Okay, so that the legal title becomes vested in the transferee. The principal forms of negotiable instruments and or are promissory notes, bills of exchange, foreign and inland checks. What foreign and inland? And checks. See forms in the appendix. Okay, so we might actually do that. Negotiable instruments are an important factor in business transactions of the present day, passing Jeez. Is this what's going on right now? I don't even know how this got messed up. I don't know how that got messed up. Okay. Well, we've been having some storms lately. I think that's messing up the broadcast signal.